Good morning, everyone. Thank you very much for joining us. My name is Philine Wehling. I am a legal officer at UNIDROIT, and I'm very pleased to chair this panel today. I am sure it will be a fascinating discussion, and I hope you all will enjoy it. Our panel discussion will explore the role of the UPICC in shaping and interacting with national legislation and in fostering regional integration. So this title refers us to the last sentence of the preamble of the UNIDROIT principles, which sets out their purpose and states that, I quote, "They may serve as a model for national and international legislators." This in turn takes account of the fact that legislative drafters always look for a model for inspiration, for instance, in the legislation of other countries. Of course, the text of the preamble sets out this application of the principles in a very general manner. The comments to the preamble provide some explanation. They state that the principles may support lawmakers in the drafting of legislation in the field of general contract law or with respect to special types of transactions, in particular to update their law to current international standards. Our panelists today will lay out practical examples for us where national legislators used the UNIDROIT principles in this very function, namely as a model for updating contract law. We will hear about the recent reform of the Chinese Civil Code and about new case law in South Africa. In some cases, national legislators face particular challenges when considering the UNIDROIT principles as a legislative model. Here we will learn about the particular challenges that national legislators in Arab states face when using the UPICC, in particular because legislation, including contract law, here has to comply to varying degrees with principles of religious, precisely Islamic law. Moving beyond national legislation, the principles may serve as a model for regional law reforms too. And here we will get insights about recent regulatory developments with regard to ESG, supply chain regulation in Europe. Now let me introduce the panelists in the order of their presentations. We're very happy to have such a group of highly qualified experts with us on this panel today, starting with Professor Wenhua JI. He is professor at the School of Law of the University of International Business and Economics of Beijing, China. And he is also a UNIDROIT correspondent for China. And you can find the bios of all speakers in the brochure for this conference. So I make it very brief. Welcome, Wenhua. We're very happy to have you with us. Eesa Fredericks is an associate professor for private international law at the University of Johannesburg, South Africa, and he has been a member of the UNIDROIT Governing Council since 2019. Professor, thank you very much for joining. Nisreen Mahasneh is a professor for private law at Qatar University, and her research areas include the CISG and the UPICC. Nisreen, we're happy to have you here. Ulrich Schroeter is a professor for private and comparative law at the University of Basel in Switzerland. Among other positions, he is a member of the CISG Advisory Council. Welcome, Professor. We're happy to have you. And lastly, we will have an intervention by Professor Marcel Fontaine, who unfortunately cannot be here with us in person today, but we're glad that he is going to connect online. He is Professor Emeritus at the University of Louvain at Louvain-la-Neuve in Belgium. And among other things, he was a member of the working group that elaborated the first 3 editions of the UNIDROIT principles. And he was the expert in charge of drafting the OHADA Uniform Act on Contract Law. Thank you very much, Professor, for taking the time to connect online. So now, before we start, I kindly invite all panelists to adhere to the 15 minutes allocated to each presentation. So we have sufficient time for Q&A at the end. Okay, the first presentation, please, Professor Wenhua, the floor is yours.
Okay, thank you very much. It's my great pleasure to be here today. So first of all, I would like to convey my sincere thanks to the UNIDROIT to Professor Ignacio Tirado, to Anna, and to Philine for inviting me, because I was invited to make some presentation concerning the influence of the UNIDROIT principle on the Chinese civil code, and you can see this is a very challenging topic, and we only have 15 minutes, so I try to think about how to guide you to this topic in a very succinct way. So I divided into my presentation into 3 parts, generally, and because in Chinese law and Chinese contract law, and indeed experienced 3 stages of involvement in the past 40 years. So at the beginning, I will briefly introduce the evolution of the Chinese contract law and its interaction with UPICC. So and how when the UNIDROIT principle started to influence Chinese law and how it do that. And the second is the main cause, of course, the concerning from the legal perspective, the legislative perspective, how the UNIDROIT principle impact the Chinese legislation to what extent it impacted Chinese legislation. Of course, some examples, successful examples, some examples of we cannot say these accessible, but some areas and need to be further explored. The third point is the final point is the concluding remarks. So I have everything in my PowerPoint, so I will not read my PowerPoint, but for any expert you have interest, I will be very happy to share with you, because I put a lot of, it's a very lengthy one, but I won't read it line by line. First, concerning the timeline, the evolution of Chinese contract law. So starting from the late 1970s, China began to promote reform and opening up. So Chinese economy and gradually was transformed from a planned economy into a market-based economy. Contracts was more often used by the business circles. So there's urgency for a specific legislation on contracts. During the planned economy, there's no any specific rules or regulations, not to mention laws concerning contracts. So in 1981, 85, 87, Chinese NPC, the National People's Congress, promulgated three separate contract laws: economic contract law and foreign economic contract law, and technology contract law. The foreign economic contract law applies to transactions between Chinese and foreigners, and the first one only applies to domestic transactions. So we have 3 pillars of Chinese contract law at that time. Okay. Oh, no, not myself. The first one. Yes, next. Okay. And China joined the UNIDROIT in 1976. And 10 years later, and NPC decided to adopt a unified contract law, because we have three contract laws with, and because at that time China did not have much experience on legislation, and also but more than 10 years later, in 1993, the NPC decided to adopt a unified contract law. So one requirement when drafting this unified contract law is to draw successful experience from overseas countries, also to harmonize Chinese law with international conventions and practices. This is the requirement from the Chinese leaders and from the NPC for the legislators. When you draft the Chinese unified contract law, you should take those international experience and legal instruments into consideration. But at that time, and for the Chinese legislators and scholars, and their view differs on whether China should conduct more about the civil law or countries or common law countries, because that's the main difference. Because only CIFG was the available legal instrument at that time. Fortunately. Okay, and in 1994, and the UNIDROIT published the first edition of the UNIDROIT principle, and the Chinese version was published in 2 years later in 1996. And immediately it's public, it's translated in China. It becomes an important reference for the Chinese legislator because the drafting of Chinese contract law was undergoing. So the legislators were very happy to have these new documents as their reference. I could say that starting that point, the UNIDROIT principle and have influence on Chinese laws. Or 3 years later, China's the contract law was published or was adopted by the NPC. So I could say that, that from the perspective of time and the UNIDROIT principle would come up at the right time for China. Otherwise, we won't have this very important legal instrument to digest before when China enacted its first unified contract law. So under the following and more than 20 years, 15 years later, in 2014, China decided to formulate a unified civil code. We have several separate laws concerning civil law, general principle, contract, tort, and something like that. But in 2014, China decided to have a unified civil code, and it takes 6 years. The full text of the civil code was adopted by NPC, and including enhanced contract section. So when I'm talking about the UNIDROIT principle on Chinese law, indeed, I'm talking about the impact on the contract section of the civil code. So this is I quote some quasi-official statement concerning China's contract section of the civil code. What's its difference? The contract section of Chinese civil code is, of course, and based on the 1999 contract law, and made a comprehensive amendment and improvements. Of course, on the one hand, it has a lot of Chinese characteristics. On the other hand, it made a lot of reference to international conventions and model laws, and has a distinctive characteristic of the time. So this is something I just translated the quasi-official statement when the law was published, adopted by the NPC, and those languages are used by the NPC to see, okay, how this law is good, because based on the old law, but we made a lot of new amendments and improvements considering Chinese characteristics and also taking international trends into consideration. So that's the general trend of China's, the evolution of China's contract law. Then we'll go to the second point, and how and to what extent the UNIDROIT principle influenced Chinese law. And first, from the process, we can see that the influence of the UNIDROIT principle is a continuous and a gradual process, starting from we can say that starting from 1994, 5 or 6, with the Chinese translation was available. So until now. So, but the mode and the reference for Chinese law from the UNIDROIT principle is not a wholesale or systemic transplantation. On the one hand, the Chinese law, contract law, and the UNIDROIT principle are relatively consistent in terms of the overall concepts, such as freedom of contract and good office, fair dealing. On the other hand, on specific provisions and rules, Chinese contract laws will refer to the corresponding articles in the UNIDROIT principle, and then the legislator will consider whether or not they could be introduced or could be adapted according to the situation in China. So this is the phenomenon I observed when I studied this topic. So I would like to give some of course, examples is used for you and for me to understand the situation, because and the UNIDROIT principle, the 1994 edition, and during the enactment of the 1999 Chinese contract law, influenced China's legislation. So, and a lot of a number of public available articles have been published in this regard. So today I will not reproduce those examples. I would use some new examples, which those new examples is relating to some of the UNIDROIT principle that were not incorporated in China's 1999 contract law, but has been included in the 2020 Civil Code, which I think this will better specify the continuing impact and the value of the UPICC of the UNIDROIT principle in promoting harmonization of contract law worldwide and its impact on Chinese law. So the first example, okay, is initial impossibility, of course, and the UNIDROIT principle, and in Article 31.1 concerning that the validity of the contract were not affected by the initial impossibility. The Chinese law and the 1999 contract law does not follow this principle. Basically, it said that okay, such without upon the ratification of the OHADA and such kind of contract should still be effective, but without the ratification, maybe the validity of a contract is doubtful. So, and in the new law, in the Civil Code 2020, and of course, Chinese law said, okay, if the ownership is unable to get unable to transfer due to the fact that the seller failed to obtain some certain rights, the buyer may rescind the contract and request the seller to bear the default liability. By stating this, and indeed the law says that okay, the contract is valid, but you could rescind the contract. So indeed acknowledge the validity of the contract from the beginning. So more or less follow the same rules in the UPICC in the UPICC. The second point concerning hardship, of course, and the UNIDROIT principle has a very good article concerning hardship. And in 1999, the Chinese contract law, after debating, did not include a hardship clause, and it's widely considered as a legal omission. But this issue was debated during the drafting of the China's 1999 contract law. Now the new Civil Code clearly and changed the tone in this regard. It not only have have an article concerning the hardship, we call it the change in circumstances, but the rule follows the UPICC's logic, implying the principle of the change in circumstances. A contract section of China's Civil Code introduced an obligation for the parties to renegotiate and require consultations to be held within a reasonable period of time. And finally, the court and the arbitration tribunal could modify or terminate them. So we can see that it is widely recognized that these rules is based on the UPICC principle. The third one is concerning the assignment of transfer of a contract, of course, and I will not repeat what the UPICC stated in Article 919. It's basically makes some distinction between a payment of monetary sum or a right to other performance, but depends on whether the third party is a good faith third party or not. And the Chinese law does in 1999 indeed and does not follow the UPICC's logic. The Chinese law of 1999 Chinese contract law said okay, and the creditor may transfer his right, except that the transfer is not allowed, but make a transfer. But if the transfer is not allowed according to the agreement, so such transaction or transfer will be legally could be challengeable at the court. Sometimes it means the transaction will be illegal. So and the 2020 contract section of the Civil Code and added one important sentence based on the article, based on indeed that this sentence formulates the logic in UPICC's principle. It's basically said, okay, for non-pecuniary claim, if such rights was transferred, you cannot be asserted against a bona fide third party. And for the parties, if where the parties agree that the pecuniary claim may not be assigned, such agreement may not be asserted against a third person. So the logic is the same. Okay, for the monetary right, you could transfer, and any third party could enjoy enjoy such right, and could use that against any claim. The fourth example, okay, is compensation. This is an example that the China law continue to deviate from UNIDROIT principle, because the compensation and the UNIDROIT principle and provide for compensation also allow for non-pecuniary damages. The Chinese law and have during the legislation process, this issue was debated, but finally the Chinese contract law still does not clearly provide for the principle of full compensation, and also the Chinese law does not explicitly provide for non-pecuniary harm either. So logically and legally speaking, under Chinese contract law, the non-pecuniary damages in principle are not available for simple breach of contract. But of course, and if the breach of contract and the tort occurs concurrently, and the compensation for non-pecuniary harm is possible. So this issue is in China is still debated by legislators and scholars. So as concluding, I would say that just to repeat, China continue to refer to the international conventions, model laws, and contract laws of other relevant countries or regions. The UPICC is one of the most widely referenced, of course, and China, I think looking forward, UPICC will continue to have a positive impact on the development of China contract law and adjudicative activities. Of course, and I hope that China's contract law or its practices will in the future will make a further contribution to the development of UNIDROIT principle in this regard. Okay, this concludes my presentation. Thank you.
Thank you very much, Wenhua, for this very interesting presentation, which really showed very nicely how the UPICC have influenced Chinese contract law. And it connects very well with the next presentation, which will address the influence of the UPICC on South African law. Please, Eesa.
Thank you so much, Jay. Thank you. And you know what, ladies and gentlemen, I'm the one that's sitting right next to the speaker, and I have to pass on these notes to tell him that he's out of time. so it's all well and good when the one passing it on, and I hope that I don't suffer the same fate. Ladies and gentlemen, thank you so much to the UNIDROIT Secretariat, of course, and of course, Philine also for including me into this program and on a more or less last minute basis. I appreciate that much. Yesterday when we spoke, you told me that, look, from the presentation, and Philine and I spoke a little, and she said that perhaps some preliminary remarks will be in order for colleagues, friends, and delegates here that's attending our conference to have an understanding of how the South African legal system works. Philine, I want to say just very, very briefly, quickly, that the South African legal system is dissimilar to many legal systems in the world. It's what we would call the mixed jurisdiction. Some would even call it a hybrid jurisdiction, because it's a mixture between Germanic civil law, the Germanic civil law tradition, as well as English common law tradition, and then some. I purposefully say and then some, because in recent times our legal system has expanded and developed. But the reason that I'm saying that is so that you can understand when I'm speaking about the influence of UPICC, or the UNIDROIT principles, on our legal system. It covers, and we make much of a fuss of it, yes, as Philine has explained, case law. Because case law, dissimilarly to many civil law jurisdictions, is precisely there where our law, if I could, call it in plain terms, where our law is made from a South African perspective. So it's a primary source of law. Legislation, of course, would be the primary source of law, but we don't have legislation in as far as private international law is concerned. And then, of course, what is growing very much in stature from a South African perspective, and I think also from a common law jurisdiction, would be the input or the feedback remarks from academics. And that is exactly one of those areas that I would like to try to touch on and discuss in a little bit of detail, if the very strict timekeeper doesn't stop everything in its tracks. So the first thing that I want to mention is, of course, and you'll see the pictures that I use, is the law of contract in South Africa. That is to show substantive law. That is perhaps one of our primary sources of South African contract law, substantive law, from a substantive law perspective. And you must understand, when we went into this type of research, we were, shall we say, uncertain yet optimistic. Remember that just about 25 years ago, something like the UNIDROIT principles was unheard of. It was virtually invisible from a South African perspective. Just yesterday, we heard that some presenters speaking about in jurisdictions where colleagues or where parties as well as lawmakers would be more likely, to have heard of UPICC. Imagine in jurisdictions like Africa, South Africa, where that has been virtually untouched. But from our research, we picked up some fascinating observations, and I'm hoping that you would see that. Even if you pretend to be fascinated, it would mean a lot to me. From an academic proposal perspective, the first time that we actually came across UNIDROIT, the UNIDROIT principles in use of our substantive contract law is through two professors already in 2001, Professors Nudia and Lub, who used Article 731 of UPICC. And I'm sure I needn't remind you that that deals with the right to terminate contracts in their guidelines. And this is now Prof. Nudia and Lub's guidelines for the further development of domestic South African law of contract in respect of cancellation for material or fundamental breach of contract. In fact, the title of their contribution back in 2001, and remember, it would have been in its infancy, the idea from a South African perspective was already cancellation for material or fundamental breach, a comparative analysis of South African law, the CISG, and the UNIDROIT principles. So, in their discussion, these professors actually, I must add, changed the law or the substantive law of contract forever, in the sense that now, especially since the argument or since the academic exercise in their writing was about the determination of materiality. Because look, from a South African perspective, from our common law perspective, contractants, this is now with the exclusion of a lex commissoria or a consensual clause within the contract, allowing contractants to cancel the contract at the site of any kind of breach. In the absence of that, contractants are only afforded the remedy of cancellation if there is a material breach of the contract. And material has been described by many of our predecessors, our academics, as when the breach is so severe that it goes to the root of the contract. Now you can imagine when the breach is not that way, then it would probably not be seen as a material breach, or will it? And this is precisely what these professors were trying to establish. And they came up and they made this observation that, look, despite there being numerous attempts to lay down an integrated approach as well as this integrated approach of how materiality should be dealt with from a South African substantive contract law perspective, the UNIDROIT principles formulation of fundamental breach goes beyond that of the CISG or any other of our understandings. Substantial detriment is merely one of the factors which the court must consider in deciding whether cancellation should be allowed. The factors B and C, and here reference is made, of course, to strict compliance, non-performance is intentional or reckless, non-performance gives the aggrieved party reason to believe that he cannot rely. And these are just some of the provisions that I'm referring to from the actual provision of the UNIDROIT principles. It emphasizes a distinct consideration, namely the need to obviate uncertainty as regards whether a contract will be duly performed. The last factor, which brings the effect of cancellation on the contract or the contract breacher into play, ensures due regard be had to the interests of the contract breaker. So what Lub was actually meaning here, what these professors were actually meaning is that now it appears that we somehow have broadened our scope of determining what materiality could be. So that's extremely important for our purposes. Then comes in the negotiations in good faith. It's 1.1.2 that you see, and I'm not going to go into the conversation that we had yesterday, although there has been some development in as far as good faith is concerned, and perhaps that discussion should be left open for another day. You know, particularly from the UK perspective, because I've given actually my students research to go and have a look at the UK bona fides, what we call it, good faith. But what Professor Sig Iceland actually says in this particular regard with reference to, and you can see the Vodacom, the grand Vodacom building there in Makate, is perhaps the opportunity has come to express itself in South African law as well as our constitutional court on the duty to negotiate in good faith. Yes, our constitution does recognize this duty. However, it did not provide sufficient guidelines for the lower court in this regard. And Professor Iceland then actually does something unconventional, and he makes reference to Article 2.115 of the UNIDROIT principles, dealing with negotiations in bad faith, as a matter of fact. And he believes that that would be a starting point. And he says that although the Constitution of South Africa provides the basis for the use of UPICC in developing the law, this has not yet been argued or proposed in any reported case. The obligation to negotiate in good faith has not yet been clearly established in South Africa, but this particular Makate case may provide the impetus for such a development. I wish I had some time just to work through, nudge, nudge, wink, wink, about the facts of this particular case. It appears to be simple, but it gets complicated. However, what the court, Professor Sig Iceland mentions here is that negotiation in bad faith involves parties entering into negotiation without intent to reach an agreement or deliberately misleading the other party about the terms of the contract. And here he even expands upon the provision of the duty to negotiate in, negotiation in bad faith from the UPICC. Liability is limited to the losses caused to the other party, and the aggrieved party may recover expenses and lost opportunities to conclude another contract, but may not recover the profit if the original contract had been concluded. Some more. Yeah. Moving on to our case law. And this is again, what I mean to say is vital from a South African perspective, because this is as a result of our principle of precedence, that a decision that was taken by a higher court would be recognized and, shall we say, not only observed, but we could say that the courts would find themselves bound to that decision in lower courts or even of courts of the similar level. And in a business doctor consortium versus Old Mutual Finance, there's the building. You could see it's a rather complicated set of facts, and I'm not even going to try to summarize them for you. Although I must tell you that the court used here, and interestingly enough, it was Judge Will. There's another Will that you may know, but it's not him. It's Judge Will that expressed himself on all three of these decisions. And dissimilar to what Prof. Lauro had actually mentioned yesterday, where the parties had actually expressed a selection of UNIDROIT principles or along that line. Here, it didn't go about that. It was about the substantive principle that had to be covered by the courts, and in passing, or the courts in arriving at its conclusion, actually, it actually had to the court made use of Article 4.3 in this one case, which speaks about relevant circumstances. And here the court says the applicants argue for a partnership between the group and the applicants, essentially in accordance with the terms of the way forward agreement and in accordance with the strategic plan. The core argument is a context argument about mutual understanding, and that's precisely why the court believed that the UNIDROIT principles could be taken into consideration because of relevant circumstances. And this speaks to the interpretational dimension of South African substantive contract law. The other case is Concretec versus Moore, where the court actually made an observation similar to the one that was taken by Prof. Iselin, and that's Article 2115 of UPICC. And the court here also, just like Prof. Iselin expands a bit, he says it bears emphasis that the first respondent initially contended that this second addendum was not in writing and was not signed by him. However, the first respondent's conduct undoubtedly demonstrated a shared understanding and acceptance. Notably, bad faith may exist where one party continues to negotiate with the other party without any intention of agreeing with the other party. I think that was a correct understanding of negotiating in bad faith. Ladies and gentlemen, I really want to jump. There's another case that I would have liked to speak of. However, I want to jump to the influence, of course, of the academia. And in a recent decision, in a recent contribution, as you can see, the authors that I think you may know had actually expressed themselves on mandatory rules or overriding mandatory rules. And here it was suggested that the effect of an overriding mandatory rule on contractual liability should be determined by the law applicable to the contract, a conflicts rule, unless the mandatory rule itself stipulates the effects in which, or it should have in this regard, which is a substantive rule of private international law. That is a substantive law provision that forms part of the conflicts rules or instrument. The second part of the provision was inspired by Article 331 of UPICC. And if I can remind you that Article 331 sub-Article 1, shall we say, just refers precisely, well, not verbatim precisely, but precisely to the observation that Professor Niels and myself made. And then, of course, the African principles on the law applicable to international commercial contracts. And in previous discussions that we had at the Governing Council, I referred to these principles, and these principles are actually as a result of a project or the project. We have other projects at the Research Center for Private International Law in Emerging Countries in South Africa, at the University of Johannesburg. However, this we could say is it's the project. And I'm out of time, ladies and gentlemen. However, I could maybe just whet your appetite to show you that some of the, I'm sure it's not going to be that much to ask from the chair, just to demonstrate perhaps that Article 4.1 speaks of, and I'll highlight very quickly for you, a choice of one or more of the following instruments is recognized on the same level as a choice of the law of a country, the UNIDROIT principles of international commercial contracts. Article 4.2, very briefly, if the parties choose any of the instruments listed in the one that I just mentioned right now, the UNIDROIT principles of interpretation of international commercial contracts may be used in its interpretation and supplementation. Article 4.3 echoes paragraph 3 of the preamble, and it speaks of the following instruments may be applied where relevant to UNIDROIT principles of international commercial contracts, but the most far-reaching provision for us is Article 7, which speaks of the role of international instruments. The law applicable to a contract by virtue of this instrument may be interpreted, supplemented, and developed along the lines of the instruments listed in Article 4.3. And Article 4.3, as I've just mentioned a few seconds ago, refers to the UNIDROIT principles, the CISG, and the UCP. We do have some future endeavors, of course, but perhaps we could be engaged with that at the end of the session, at the discussion or the informal discussions after our session. I thank you so much, ladies and gentlemen, and for accommodating me with this. Thank you.
So thank you very much for this interesting presentation.
Thank you very
It
much.
really nicely showed how the UPICC
Yes.
can shape also case law, and then referred to the African principles, where actually the UPICC take more a role of influencing a soft law instrument. So now we move on to the next speaker, Nisreen. She will address the compatibility between the UNIDROIT principles and Islamic law in Arab states. Please, Nisreen, the floor is yours.
Thank you very much. I appreciate the opportunity to be here today and participate in this esteemed conference. I extend my heartfelt gratitude to UNIDROIT and Professor Anna Benziano for extending this gracious invitation to me. The title of my presentation is the UNIDROIT Principles and Islamic Law, and the title you are seeing in the screen is the title of the article I specifically authored for this conference. Given its extensive content, I regret that I will not be able to delve deeply into all ideas presented. During the allotted time for my presentation, I will first elucidating the Islamic law of contract. Subsequently, I will outline the questions posed in the article, followed by a presentation of my primary findings from this study. Each finding will be discussed briefly. Finally, I will offer conclusions drawn from the study and propose recommendations based on these conclusions. Okay. Count this down. Okay. Starting by elucidating the law of contracting, the Islamic law of contracting. Contractual dealings under Islamic law are not considered religious issues. They relate to people life. The rules of contracting are scholarly work that embodies strengths and weaknesses. However, these rules of contracting must adhere to the mandatory rules of Sharia. Maybe the most important mandatory rules in Sharia that relate to contracting are the prohibition of usury, riba, and uncertainty, which is referred to as gharar, in the sense that all contractual dealings under Islamic law must be free from these two elements. Unlike other legal systems, there is no general doctrine of contracting under Islamic law. Instead, there are various applications relating to each contract. And each rule of contracting under Islamic law is linked with objectives and rationale, and I will give some examples later. I see it important here to indicate two international Islamic organizations that aim at presenting a modern and renewed image of Islamic law by finding Sharia-based solutions to emerging problems in a contemporary and practical manner. And those are the International Islamic Fiqh Academy, which was established in the year 1981 as one of the bodies affiliated institution of the Organization of Islamic Conference. And the other one is IOFI, and IOFI stands for the Accounting and Editing Organization for Islamic Financial Institutions, and it was established in the year 1991. These two organizations played instrumental role in setting out rules for banking and insurance in compliance with Sharia. Now I will move to the questions. No scholar can, in one article, compare all the rules of the UNIDROIT principles with their counterparts under Islamic law. Therefore, I decided to link this comparison with a legal question, by which the comparison, it's not the objective of my study. Instead, it serves as a tool that helps me to find the answer to the legal question. From my experience as a scholar, the application of the UNIDROIT principles in the Arab Islamic countries is limited. What is more, in many occasions, I found that law graduate students, lawyers, and judges have no idea about the existence of this legal framework. So I decided to raise these questions. What are the common areas between Islamic law and the UNIDROIT? What are the main differences between the two instruments? Why these differences exist? What is the rationale, the objectives of the rules under Islamic law? And the most important question is, to what extent the limitation of the UNIDROIT principles impact within the Arab countries is attributed to the assumption that the principles contradict with Islamic law. And if this is not the reason, what then are the factual reasons? Okay, next one, please. Okay, these are the main findings. There are some rules that similar or close. The Islamic law is close to the UNIDROIT principles or exactly the same. There are some rules that are different between them. And there is this limited impact of the UNIDROIT principles within the Arab Islamic countries. Next slide, please. Okay, these are some examples of the areas where both the UNIDROIT principles and Islamic law meet. Either it's the same rule or it's very close to each other. And given the restriction on the limited time, due to the limited time, I will not be able to go through all of them, but I'd like to shed some light on 3 of them. I will elaborate briefly on inconsistent behavior. Inconsistent behavior, this is an important rule under the UNIDROIT principles, and it has a counterpart under Islamic law. How is this? Under Islamic law, there is a distinction between internal intent and external intent. The contract is not born by internal intent. Such intent must be shown in words or actions. And the rule is both intents must be identical to each other. If otherwise they are not identical, the external intent prevails. And here there is an important principle in contracting under Islamic law, and this principle says, whoever attempts to undo what he has done shall not benefit from its attempt. The second issue I want to comment on is cause. There is no doctrine of cause under Islamic law for contracting. Cause is not required, exactly like the case under the UNIDROIT principles. Instead, there is something called the content of contract. And this is decided by Sharia, and it refers to the genuine intent of contracting, which reflect the same concept in each type of contracts. For example, this genuine intent of contracting in all sale contracts is ownership and utilization in all lease contracts. The final or the last one topic I want to comment on is limitation periods. Under Islamic law, rights are not extinguished because of the passage of time. Instead, the claim of such right is barred, and this is the same rule adopted by the UNIDROIT principles. The rationale behind this rule under Islamic law is that the creditor who does not request performance for a long time is negligent and must not be awarded. Next one, please. Okay. I used to have interactive classes when I teach. And I want to make this presentation interactive. Because I will not be able to comment on all of these due to the time limitation, I will ask you to choose 3. And first come, first serve. Force majeure, okay.
Specific performance.
Interest is very straightforward. Okay. I will make it extra one. Very, very straightforward. Specific performance, okay. And okay, 5 minutes. Oh my God. Okay. And a third one, if time damages. Oh. Okay. Okay. Force majeure. Don't count this side. Okay. There are some similarities between the UNIDROIT principles and Islamic law in terms of force majeure, but I will concentrate here on the differences. The first difference is that force majeure under the UNIDROIT principles reflect impossible performance and delay in performance. Islamic law restricts the case to impossible performance. Number 2, under the UNIDROIT principles, the party who's facing the impediment must prove this. This is not required under Islamic law. Third, the similar issue between them, or the most similar thing between two, that damages are not foreseen. Damages are not foreseen under both. The most important difference between them is that under the UNIDROIT principles, the contract stays alive and the other party can exercise some rights, provided that the conditions of each right are satisfied. Under Islamic law, the contract is terminated automatically and the contracting parties are returned to their initial position before the contract is made. And finally, the rules of force majeure under Islamic law are of a mandatory nature, and the contracting parties are not eligible to agree otherwise in advance, because rights are not subject to waiver before they born. But once the event occurs, they can agree otherwise. This is about force majeure. Specific performance. Specific performance is the only remedy for a breach of contract under Islamic law. It's a primary one and the only one, and the innocent party cannot choose between specific performance and termination. Why? The view, or this view, is rooted or justified in the principle of keeping promises. Now, under Islamic law, we need to differentiate between two things. On the one hand, creating the contracts and its terms, and this is the sole responsibility of the parties. On the other hand, the consequence of contract, which is performance, and this is decided by Sharia, and it's the right of God. That's why specific performance is the only remedy, and this reflects an absolute application of the principle of binding power of contracts. Okay, 2 words about damages. Damages is not a remedy. It's not a remedy. Yeah. The consensus among Islamic jurists is not to award damages for a breach of contract. Damages under Islamic law is exclusively associated with the destruction of the specific subject matter of contract by the fault of the debtor, in which case he must pay the value of the item at the time of performance. And it is not called damages, it's called daman laqd. Why? Because this position is rooted in the prohibition of usury, riba, which cases for breach of and moral harm flow because it can by monetary not unmeasurable. Okay. Translator, I'm sorry for to conclude, please. Can to the rules of the UNIDROIT conduct with Islamic, they are different. One can say that is not adopted or Islamic countries. We can see commercial bank deal insurance contracts. I think the UNIDROIT principle is not begin. This is not the reason that the contradiction is not the or the factual reasons. Two words here: representation map of Arab working representation is or completely. Number two, national trained to apply the cannot liberate from domestic are that deep the must be established among Islamic countries and make existence of they must be a nature and that do not between commercial and the flexibility of the applicable not only to commercial contracts but okay, yes, دقيقتين is fine. But only they are applicable to domestic and civil contracts. In some, the effective use of the principles in Arab Islamic countries highly depends on the horizon of the judge and its ability to think out of the box. However, this will not come without a methodological plan that starts from the law school, the curriculum in the law school, accompanied by continuous legal education for legalists on the recent developments in the field of law of contracts at the international level. Thank you very much, and I'm sorry for exceeding the time.
شكرا جزيلا نزرين. Thank you for the wonderful presentation. It's not connecting. Okay. So we will move on to the next presentation. Professor Schroeter will present to us, taking a very different perspective, the interaction. He will focus on the interaction between the UNIDROIT principles and recent regulatory developments in Europe, both at the national and at the regional level. Please, Professor, may I invite you to take the floor.
Thank you very much. It's my great pleasure to speak to you today, and thank you for the invitation. I will commence, if I have the clicker, then just stay away from the cursor. Yes. All right, ladies and gentlemen, indeed, as already indicated, contrary to my fellow colleagues who you have just had the pleasure of listening to, I will not be talking about the influence of the UPICC or the principles on supply chain regulation, but on the interaction between the two bodies. And the reason is that, as far as I can see, the UNIDROIT principles have had no influence on these new regulations that have come up in the past years, nor did any other area or other contract law regime. Indeed, it is not quite clear whether contract law and its dimension has been taken into account at all much when those regulations were drafted. Against this background, I will be addressing the principles interaction with modern ESG supply chain regulation, an interaction that, in my prediction, will become increasingly important in the coming years. The term ESG that we already heard mentioned yesterday is short for environmental, social, and governance. And supply chain regulations create duties for companies, so not a voluntary compliance that was raised on the floor yesterday, but duty for the compliance to not only reduce the impact that such ESG factors have that are caused by their own operations, but throughout their entire international supply chain, in particular the impact caused by foreign suppliers. Article 1 of the EU directive on point that is currently being adopted, we are not quite sure yet whether it will be adopted, but all signs indicate that it will, describes this general goal that you see here. And some national legislators, like in Germany or in Switzerland, have recently adopted similar laws. The supply chain regulations differ on the one hand in their terminology. Some speak of supply chains, others speak of global value chains, yet others, as the upcoming EU directive, of chains of activities. And on the other hand, they differ in the ESG aspects that they are seeking to protect. Some regulations and so far adopt a very broad approach, as the EU directive, which covers human rights in general, the environment, and now also climate change, as you see on the screen in litera C, while other regulations on a domestic level are much more narrowly designed, as Swiss law, for example, which limits local companies' due diligence obligations to trade and conflict minerals and child labor, or the prohibition of the latter. After I had the pleasure of reading the text of the upcoming EU directive, which is quite concise because in its final version it only covers 250 pages, I was briefly tempted to make a couple of general comparative remarks on the drafting style between the directive on the one hand and the UNIDROIT principles on the other hand, but I will refrain from doing so. Instead, I will focus on the tools that supply chain regulations employ, and most of those tools operate quite separately from the contracts that the company that is subject to such regulations concludes, so that any overlap with the UNIDROIT principles will be minimal. This is true, for example, for transparency requirements or for due diligence duties. It's also true for the company's civil liability that the upcoming EU directive will introduce, which in essence is a special tort liability. However, some supply chain duties regulate the contracts between a company and its suppliers, and so far focusing on the supply chain as a chain of commercial contracts. In addition, some regulations go beyond a regulation of contracts by using contracts as an instrument for supply chain regulations, akin to a regulation through contracts. Cross-border commercial contracts, including those governed by the principles, can therefore be both the object and the instrument of supply chain regulation. And where they are, the compatibility with the principles is worth investigating. If we first adopt a broad perspective and ask whether the principles can, in principle, peacefully coexist with ESG supply chain regulation, two general factors both speak for such a compatibility. First, it is true that the principles, like every classical set of contract law rules, primarily seek to balance the interest of contracting parties themselves, while ESG supply chain regulations aim at the protection of the interests of third parties, the workers, the local communities, and the production aids primarily, or the protection of common goods, like the environment or the climate. So the general thrust of the supply chain regulation is quite different from the use of ESG clauses that Ekaterina has talked about earlier today. But I believe the principles are flexible enough, one may say, of course, to also govern contracts concluded between entities that have to comply with supply chain duties. And furthermore, they can accommodate ESG-related contract clauses that such parties may want or may have to include into their contracts. Second, the principles may even have an advantage over domestic contract laws when applied in a regulated supply chain. Many international supply chains are long and involve suppliers, sub-suppliers, and sub-sub-suppliers from a range of different countries. If domestic contract law provide the background to ESG due diligence duties in such supply chains, the applicable contract law may differ from chain link to chain link, so that the inclusion and validity of ESG requirements may be viewed differently in each link. A uniform contract law for the entire chain would obviously help, and its transnational uniformity could therefore make the principles an ideal supply chain contract regime. However, the principles' interaction with supply chain also raises challenges. Let me touch upon two examples, one from the supply chain regulation through contracts and one from supply chain regulation of contracts. Seemingly, all supply chain regulations require companies, and we already heard it this morning, to include into their contracts a commitment of their direct suppliers to comply with the company's code of conduct, something that the EU directive refers to as a contractual assurance. The reason is obvious. If the supplier is a foreign supplier, then the regulator regulating the supply chain end, the company residing in its territory, could not directly impose ESG obligations upon the foreign supplier. Instead, the regulator obliges the local company to contractually pass ESG standards on. In addition, the supplier can himself be contractually obliged to pass the commission on to its own sub-suppliers, and so on, a contractual cascading, as it has sometimes been called. In this way, the ESG standards imposed upon the supply chain end, or the chain leader, could contractually be extended through the entire chain by using the same boilerplate contract clause that always refers to the chain leader's code of conduct. The principles, as indicated earlier, can accommodate such contractual insurances and cascading. All they require is consent of each party in accordance with the principles' contract formation provisions. And herein lies a general challenge inherent in any supply chain regulations through contracts. Although the company at the supply chain end is commonly referred to as the chain leader, it is not the chain legislator, but merely one of the contracting parties in the chain. The only way to govern the supply chain is therefore by means of contract, by voluntary party agreement. This in turn makes the limit of the contract as a legal instrument also the limit of any regulation through contract. And a number of challenges may thereby arise under contract law in general and under the principles in particular. Let me just mention two of them. First, we need contractual consent within each link of the supply chain, which may be a long chain, which each supplier agreeing to with its sub-supplier on the necessary due diligence obligations. If one assumes that ESG violations in real life most likely occur at the start of the supply chain, namely at the production and excavation stage, the cascading has to stretch the entire supply chain with no interruption. If only one chain link does not pass the contractual clauses on, the approach fails. And there may be many possible reasons why a company within the chain may not be willing to so agree. It may find the obligations too burdensome, or it may be in business relationship with many different buyers who seek to impose obligations that conflict with each other. In addition, the contractual link may also be missing because it is invalid. For example, if the contract imposes information or disclosure duties upon a supplier that are illegal under the mandatory law of the supplier's home country. In order for the principles to apply throughout the supply chain, we would also need an agreement on the principles application in each link. And second, we have to ask ourselves whether the requirements in the modern supply chain regulations may result in the death of the informal supply chain contract. Why? The current supply chain regulations do not impose any formal requirements on the necessary contractual assurances they impose. But practically, it is difficult to see how such insurances could be established other than in writing, given that the company will have to prove to the authorities that it has complied with its duty in order to avoid government fines. Therefore arises not a conflict in the true sense, but a certain tension with the freedom from form principles under the principle. A partial solution, I believe, may lie in a greater reliance on practices established between the parties in those cases in which the company's code of conduct has already been consented to in earlier transactions, given that the parties under the principles are bound by such practices. Some further questions I can only mention here without providing any answers. Are such cascading clauses valid under the principles and under mandatory domestic law if they occur in formal standard terms? Can compliance of suppliers be supervised and enforced by the chain leader through contractual means, by imposing contractual information duties and by employing contract law remedies? Can due diligence clauses be read as clauses conferring a contractual right on third parties, for example, the workers or the neighbors? Instead, I will finally turn to, you touch the cursor. Just switch one on. Thank you. If I turn to commercial contract as an object of supply chain regulation, I will simply target the sharpest tool in the supply chain regulation shed, so example, namely the duty to terminate the business relationship with a supplier. The provision on point from the upcoming EU directive is what the EU legislator has imposed insofar. If we ask ourselves whether there's harmony or friction between supply chain regulations and the principles if it comes to the termination of a relationship with the supplier, because the supplier has violated ESG standards, we first can notice that the difference in terminology exists. Supply chain regulation typically require a business relationship to be terminated, while the principles think in terms of contracts. In substance, both regimes are at least dovetail insofar as that they both treat termination as ultima ratio, as a remedy of last resort. But the devil is always in the detail. Can a supply chain contract therefore be terminated under the principles if a regulatory duty requires such a termination? In my opinion, we should distinguish between two types of contractual relationships. The first type is a one-off contract or a standalone contract which is concluded and then performed. Once such a one-off contract has been performed, the buyer may decide to conclude another contract or many other contracts with the seller, or he may refrain from further contracts, at least if he doesn't include a not perfectly drafted ESG clause into his framework agreement. The obvious and fully principles compliant way for a buyer to terminate a business relationship is therefore simply to place no further orders. This is perfectly in line with the principles because the freedom of contract guaranteed thereunder also includes the freedom from form, the negative dimension of the freedom of form. By simply refraining from concluding additional contracts with a tainted supplier, the buyer is therefore acting in accordance with both sets of rules. The situation may be more complex in case of long-term contracts, a category of contract with the principles as of 2016 defined as a contract which is to be performed over a period of time and which normally involves, to a varying degree, complexity of the transaction and an ongoing relationship between the parties. Under the principles, long-term contracts may be terminated in accordance with Article 731, namely where failure to perform an obligation under the contract amounts to a fundamental non-performance. The first prerequisite, non-performance of an obligation under the contract, is elegantly dealt with by the supply chain regulations themselves because they make ESG compliance a contractual obligations, as we saw earlier through the contractual assurance requirement. The application of the second prerequisite, namely the fundamental non-performance threshold, is not quite as clear-cut. This is so because the aggrieved party's contractual duty or contractual applications are the ones that the principles primarily look to have traditionally been understood as commercial expectations. My time is up, and therefore I will give you in 2 sentences what I believe should be done under the principles. First of all, I believe there are some cases in which the commercial expectations may well encompass ESG compliance when the buyer is subject to fines where he loses customers. That's not always the case, because some of his customers may happily buy tainted goods because they don't know that there has been a compliance. And therefore, if there is no coordination between the 2 instances, I would say that we can say Article 731 of the principles does not attempt to exhaustively govern these type of contract formations. I believe supply chain regulations deals with a different matter, namely the protection of workers and child laborers from ongoing use in that way. And that's why I believe they're perfectly compatible. Thank you very much.
Thank you very much, Professor Schroeter, for this very interesting presentation, which is also very interesting for our new UNIDROIT project, which addresses corporate sustainability, due diligence, and global value chain contracts. We just learned that unfortunately Professor Fontaine will not be able to connect online today. So we will move on directly to the Q&A. And we will take first a few questions from the room and then see if there are any questions from remote participants. Please.
Thank you. Apologies for taking the floor, probably I should not, but I can't refrain. Thanks to all of you for this most interesting presentations. I have a question for Ulrich, and apologies if it's from someone who is ignorant on the matter. But so if we have the supply chain with a chain of contracts, which let's say to make it more complicated, the different parties to the contract being in different jurisdictions, therefore with likely different standards. Case further down the line level, for example, in the meets perfectly the local regulatory. What's more, finds it very difficult to meet the European regulatory standards because of whatever reason, really just a lack of something in that place, and doesn't fully perform, but delivers the product. What's the damage? I mean, the damage would be, I guess, the fine, that the sanction that would be received by the buyer up the chain. Would the principles there provide any sort of defense rather than something? You know, there are so many questions that could be asked in this regard. Yeah.
This is an excellent question, and it shows us that we actually have 2 different damage directions, if you will. What you're talking about is the supply chain leader or within the contractual chain. And there we would have to see whether indeed its interests are somehow disappointed, whether he has any damage. What most of the supply chain regulations aim at is not protecting the buyer, it's protecting third parties. So they give damage claims, maybe, or maybe not, to the workers that were hurt during their production, and gives them a right to claim against the supply chain end. They may also have a right against the factory owner in Ruritania who may or may not be able to say, well, I have complied with local regulations, you get nothing, but there may be a claim against the European company at the end because the supplier has not complied with the European standards that are listed in the rules, and the supply chain end has not supervised it. And that's essentially the thrust of the supply chain regulation. We're regulating from the end, in essence, the entire world, if you will. And that obviously also raises certain policy questions of acceptability. But you're right, within the supply chain, it's essentially going to be a matter of the contractual terms. And is there damages? Can you have something like a specific performance right of the supply chain and person said, we're going to go in and we're going to close your factory? That's hard to believe, but on paper, well, the real catch lies in third parties that are hurt having a claim against the party at the supply chain end. And then what nobody apparently has thought about is whether the party at the supply chain end can pass those damages on down the chain and says, well, if you heard it, we're going to pass it on, which would sort of like circumvent the entire purpose. So here we have a clash of two different worlds, and supply chain end is all done, is thought about from regulatory reasons, which have their perfect room, but the supply chain dimension, I think, has not been captured.
Thank you. So we have a question from Professor Vogenauer, please.
Yes, thank you, Stefan Vogenauer, Max Planck Law. I have a question. Well, thank you to all the panelists for really interesting and eye-opening presentations. I just have a question to Professor Ji on Chinese law. I was quite intrigued on to see on one of your slides where you referred to the various influences on the new civil code that you said it contains many Chinese characteristics, and I'd be quite interested to hear what you mean by that. Do you mean it just includes judicial interpretations or case law, or do you mean it includes characteristic doctrines, like you would say it's a French characteristic, or used to be a French characteristic, to have cause? Or do you think of something more nebulous here, like the spirit of Chinese law or Chinese legal values? And I'm asking because I'm involved in a major comparative research project on Asian contract laws, and we've always been scouting for Asian legal values that apparently seem to exist, but no one seems to be able to locate them. So could you just elaborate on the Chinese characteristics of the civil code?
Okay, thank you very much. And well, of course, and this is a very challenging question, because and on the one hand, I think I would like to answer your question from two perspectives. First one was, okay, this is Chinese civil law, contract law. So it's very safe to say of this law and bears have a lot of Chinese characteristics. But this does not mean those Chinese characteristics is unique for China. So do not read this Chinese characteristics with something that you cannot find other places. Maybe just China and have this legal tradition, and such as Chinese companies are intended to use to solve they hesitant to use litigation to solve their problems. This is the legal tradition. So we sometimes we have some laws to advocate to promote the use to promote the settlement of dispute through alternative. This does not mean that this is something that very unique to China. Of course, on the other hand, there might be some Chinese some articles which Chinese legislators, when they think about when they drafted it, based on China's practices and legal traditions. I will find some concerning I think one example is concerning the compensation, concerning the non-pecuniary damages or something like that, which I think more or less is related with the Chinese tradition, because this thing commercial contract is based on a kind of financial gains and benefit. So this thing based on China's legal practices. This thing is if we open this door and to allow for non-pecuniary damages simply for the breach of contract, in practice it will create a lot of problems, because you don't know, and you breach one simple sale or contract, selling or contract, and you will have to compensate for the mental damages caused to the buyer, and you don't know how much you could do that. So I think this might be the one example, but I would like to collect more material information to satisfy your question. Thank you.
Please.
Thank you. If we look at the 2016 update of the UNIDROIT UPICC, we have the long-term contracts, but more in a type of textbook definition, which I think is very well done. But then the normative part that was conceived as a second bit eventually had been dropped by the governing council, from what I recall. So my question is for Ulrich. In light of what you've just said, it is in many of the scenarios you've outlined fairly difficult to see how we actually can establish a breach in some of those relationships. Would you find it advisable when the PICC are next revised to reconsider establishing a rule such as the one discussed in the earlier version, or do you think it will not be necessary? Thank you.
I believe that for the purposes that I have outlined, it would not be strictly necessary, because I believe that the duty under those regulations to terminate a business relationship is essentially one that exists alongside the principles. And it does not matter at the end of the day whether the principles allow it or not. One could say this is a public international law duty. You cannot use child labor, and you cannot buy stuff produced by child labor. That's simplifying the underlying idea. So the UNIDROIT principles would not need to comply at it. But of course, it would be helpful for the parties if the termination and what happens afterwards would be regulated contractually in compliance with that. So that's why it would be helpful to have such a rule. With a bit of the 731 is fairly flexible. It doesn't only say commercial interests. One could, I believe, also interpret it as it stands to allow for ESG violations being a sufficient reason. But that comes with quite a number of uncertainties. And I should also say, when I did the basic comparison between one-off contracts and long-term contracts for the purposes here, and that's my written paper, it's not important that it's a long-term contract. It's important that the contract has not yet been fully performed. It can also be a shorter contract. But as to your question, I think that would be worth considering whether that should not be added to a new edition.
Thank you. Professor Brödermann, please.
I see here a very dangerous part. I mean, we all remember the optimistic one we write in our new ESG standards. We do contracts in good faith and fair dealing in the spirit of the UNIDROIT principles. So that's the positive aspect of yesterday. But the dangerous part for me is that, for one, at least in what I see since years in practice, code of conducts are there all the time. It's part of all complex contract packages, at least in the automotive industry, for example, or automation, many other industries. You see them. They are determinations of quality in the sense of 5.1.6. So when you act under the UNIDROIT principles, which I often do, then they become binding. And then they are also fundamental. Each of them says it's fundamental. They also refer to usually also to the UK Slavery Act. So a number of things are done. We are already then fighting at the level of contract drafting, which parts of the rules do we integrate. We have constantly the situation that we have to give advice on conflicting mandatory law. Article 1.4 is very open. Any supranational, regional, etc. mandatory law shall be respected. There are increasingly conflicting mandatory laws. I mean, the obvious right now, let's say between Russia and America, that's the obvious ones, but there are many, many other ones. Take the old Cuba sanctions, which are still in force in America, where in England and in Europe we have blocking statutes against those. So if you're a manager of an international company, you only have the choice where you don't want to go to prison, or at least risk the fines. So there is a huge part of conflicting mandatory law made, as Ulrich as you just described, without regard even to the contractual aspects. And there is some chaos coming up, and that gives some concern to me how we make this to make it livid. To add on top one example, since about 6 months, I see a lot of added then to the code of conduct, which usually is only for slavery, but they add the other stuff too, added there suddenly no fossil a commitment to not use any fossil energy, at least by 1935 or 1930. When we discuss long-term contracts of 10 years, we already reached the 1930s. How can you do that if the production, and so then the Germans add no atomic energy, all that becomes just about impossible if part of the production is in France or in other European countries which are not as rigid as the Germans. So there is a lot of concern with ESG. It's not only positive in the contractual making of the contract, even with good spirits. It gives some concerns to me, and the question whether we have to think more about the impact of 1.4 and then of course of 5.1.6. Thank you.
I just want to add something to the comments that I made, because sometimes under the ESG or supply chain requirements and go beyond the economic factors and delve into many social elements. So sometimes, and of course, and the head of the chain and the supply chain, and upon the requirement of the local requirement, would like to add the high standard to the whole supply chain. But on the other hand, and some maybe and some countries in the downstream of the supply chain could also take countermeasures. And for the head of the chain, if you take that measures against my companies, okay, the foreign countries may take some countermeasures against the head of the supply chain. So this cause add to the not only a blockage law, it's it's a more aggressive countermeasures. So I think the companies and the contractor would lie behind in the middle how to handle this, whether contractor would be able to handle this. It's an open question. Thank you.
I'm going to be brief as a response. I think in one way it is just a new case of contract law, of course, operating within the limits of mandatory law. And if we're doing with international contracts, we may have more than one mandatory law. That is as such nothing new. It gets a lot closer. And what we can think about is how the contracts can live within the limits. It will not always be easy. And what I think has Professor Ji said has not yet really be covered, that if we say, well, we're just going to put contractual duties in, there may be countries around the world who says, we will not allow the companies in this country to simply pass on data about the production and about the contracting practices we have here. That's a matter of national security. That's none of your business. What's the company supposed to do then? The supplier and the company at supply end. So there are a lot of tensions here. And I think, as always, we have to just look at it more closely and try to find a good solution. We will somehow.
Thank you very much. And we will take one last question from the remote participants. Mr. or Mrs. Castellian. Please, the floor is yours.
Thank you very much. This is a fascinating conference, and I'm very sorry that I'm not
muted. You would need to unmute yourself, please.
I am unmuted. Can you hear me now? I am unmuted. Can you hear me?
We cannot hear you.
Oh, okay.
Okay, so yes, but we also passed 1 o'clock and the end of this panel. So how would you like to write your comment and we read it out loud? So thank you very much, and then we reach the end of this panel. If Anna, would you like? We close this panel. I would have one concluding remark. For me, the leitmotif of this discussion was the flexibility of the UPICC, which proved to be compatible in most respects and useful for countries with very diverse legal traditions, civil law, common law, mixed, Sharia-based legal systems, but also with regard to new ESG developments. Potentially, this is a matter that would need to be explored more. There's some discussion in my team. Please, could you? So in either case, let me thank the panelists for the very interesting presentations. really enjoyed them. And thank you all for those who posed questions. Here, lunch will be served now at the second floor of the main building of the Institute, and then we will resume for the next panel, panel 6, at 2:15 p.m. Thank you.
Thank you.